morning.
Good morning, Your Honor.
Each side will have 15 minutes, and the appellant may reserve up to 5 minutes. We're ready to proceed.
Thank you. I would ask to reserve to 3 minutes for rebuttal if necessary.
Thank you.
May it please the court, my name is Nicholas Hannick. I represent the mother and appellant, Teresa Terry, aka App. And at the core of what I'm arguing is that the court's decision was an abuse of discretion because they were unable to look at the best interest factors because the mother did not have visitation since October of 2013. And the role of how visitation plays into the best interest factors is important. While it is not a specifically enumerated factor, it is certainly incredibly relevant to the interaction of the children with others and the wishes of the children, and it plays into what the court has to be able to determine. The mother in this case did not have any visitation from October of 2013, and essentially the result that she gets for these three children is that she's left without any visitation and only what residual parental rights would be in there. This is, in effect, akin to a permanent custody for her, for those three oldest children, with the result.
And what was the reason that LCCS gave for her not having visitation?
There are a few reasons given. The ones that I would like the court to point out, and I put on my brief, is that they did not like that she was discussing the litigation. They felt while the litigation was pending, she would discuss aspects of the case plan and the fact that they could possibly reunify. And that was part of the reason why, and it was explicitly stated, they didn't like some other behaviors of her during the visitation. She she was taking pictures of the children, and she was alleging that they were being abused in the care of the foster homes. There was no allegations that she was creating any physical harm to them, attacking them. I don't believe that there was any stating. They said essentially disrupting the children, but not saying that she caused a specific mental health diagnoses or that there's something that truly would be an imminent risk to them. There were certainly evidence presented that the mother in this case had some mental illnesses, but the court had to look at it. So the court had to look at, in essence, in a legal custody proceeding and not a permanent custody situation, what kind of visitation should this mother have ongoing, because she still has parental rights, and they had nothing for which to really look at to determine. And she's got a vague order that says, well, someday you can petition if you handle, she's got sort of a case plan in perpetuity. If they wanted to terminate the rights, they could have moved for permanent custody. This is a situation where
they're obligated to the least restrictive, so granting legal custody of paternal grandparents is way more least restrictive than permanent custody.
Correct.
So at least she has an opportunity to come back.
That's correct. But the court, I guess what I'd like to say is that the court wouldn't have even been able to consider what that would look like. What would a visitation look like with her? Because there was none in place for so long. Is that the role of the court and the Children's Service Agency in these cases, to terminate a visitation when they're supposed to be working towards a reunification?
But both parties have to be working toward the reunification. From what I understand from your brief, both parties' briefs, was that there was some reluctance on mother's part to participate in the case plan requirements, as well as her behavior during visitation.
I would have to acknowledge that there was minimal progress on the case plan at best.
And there were significant issues that needed to be addressed, from what I gathered from the briefs.
And the question, I think, the consideration is it appropriate to have that visitation restricted to such an extent that the court, we don't know how that interaction would have went, and we don't know if.
Well, we know how it did go. It was observed by people at the visitation center, correct?
Correct.
Okay, so we do know how it did go, and it was terminated.
And I guess my point, what I guess I'm trying to get at is that appropriate? Should, at that point, they decided that this mother's not working the case plan, we don't want this mother to see this children, but they did not move for permanent custody at that time. They had that mechanism.
Well, they had, I thought, taken some steps to correct mother's behavior so that, to Judge Schaefer's point, by having custody in a relative, it still presented an opportunity for mother to, continue with her residual right and possibly come around, if she's following a treatment plan, to come around to a point where she could have visitation restored. Did I read that she did not later file or ask to have visitation restored?
That would be, I think there's a little complicated history. She did it, this was up before the court as far as an earlier appeal regarding the adjudication. And I don't know if, I'm not sure, there's been a number of attorneys with her and a number of difficulties that probably result from having obviously someone with active mental health issues.
Sure.
And no, I don't think there was a motion in there, but I guess there's a difficulty in dealing with someone who's not, while there is expressed mental illness, who's to say she couldn't do a visitation, or couldn't do what you would look at in a private custody determination of legal custody? I mean, what sort of time? I don't think the court had the information to fully look at it.
It seems like, we're balancing giving the mother visitation in order to establish, even though we see, or the agency saw that things were not going well, there's a tension between giving her more time and giving her more visitations so that they can be observed. And that's balanced against the best interests of the children in what they're being exposed to during the visitations that, that have been observed. And so I understand your position that you want to give her time. I also understand, and I think you understand, you're acknowledging there are a lot of difficulties because of the mental illness. But how does the agency protect the children even from the visitation, from the effect of the visitation? Do you kind of wait until, some psychologist needs to come in and say, these children are irreparably harmed? Taking pictures of their private parts and discussing whether or not they're being sexually abused. Think about the harm.
There are a lot of parents in these situations, in custody situations, and invariably will talk about the custody status. And sometimes that's a symptom of mental illness, sometimes that's just a vindictive person, and sometimes there's different avenues. But I don't think that precludes them from seeing their children.
If it would encourage a child in foster care to make false allegations against a foster parent, wouldn't that be detrimental to the child?
Certainly, that would be detrimental to the child. I think in this, I would argue that was not the case in this situation, especially with a lot of what some of the youngest child was nonverbal, would not have been able to make those kind of, so it's kind of a hypothetical, but of course that would be detrimental had something like that occurred, been presented. I would just imagine there would have been difficulties in those visitations, but I don't see her as off the field of someone who is just, it's their mother. There is a mental illness component. There's a mental illness component, but as far as is she so far out of bounds as to never see them during the pendency of this case, I would argue no. And
And what's our standard of review on that issue?
well,
Is that
I'm
use of discretion?
arguing as a whole that it is unreasonable for the court, I'm arguing abuse of discretion because I'm saying it's unreasonable for the court to make this determination out of a situation that was aware of and created within the court. That she couldn't even have it evaluated as to if maybe she could have done a once a month visitation or permit, maybe phone calls or things like that. There could have been some level of something. If they wanted to terminate her, they could have terminated those rights. And I don't think the court could determine anything, could have determined something appropriate for her, given the fact that I'm not arguing that these kids could go to her home or care for. I'm saying that she has some ability to communicate and contact, and I think that could have been a possibility. And obviously, the agency had other mechanisms, especially older children, like a PPLA or things, some sort of thing she had some sort of ability where we acknowledge that they're not going there, but she maintains that relationship. The court didn't have the ability to determine that because of the situation that it was both imposed and created. And I do find it troubling, partly in that the agency acknowledged that part of the reason is the ongoing litigation, and that can be taken a couple ways. I know that I could see that talking about the case and talking about this with the children could be detrimental, but that may not be the only. There's obviously a dual goal in agency to try to reunify and to try to look for permanency, and I think they went straight to the permanency, precluded a little bit the option of reunifying, and did not give enough for this court to look at for what is a final solution for these children. These children were, as you can see through the briefing evidence, they were bonded with mother. They wanted to maintain some kind of relationship with mother, and the court could not determine anything that would have been a realistic relationship ongoing other than a termination based on what happened.
At that time, but she does have the opportunity to come back in the future.
The reality is, unfortunately, that if she does not, she may not have that opportunity based on the realities of mental illness and poverty and who and where she is. And so as a practical matter, I can't say that it isn't like a permanent custody. I mean, explaining.
Counsel, you're in your rebuttal time, by the way. That's up to you whether you're going to proceed.
I will say my time with all. Thank you.
Good morning, Your Honors. May it please the Court, my name is Faye Sutton and I represent Lorraine County Children's Services. In listening to the questions you've asked, it appears that you have a pretty good understanding or review of the transcript in this case. The unfortunate fact of the matter is that it pended since July of 2012. Mother, in that period of time, was in a downward mental health spiral. If you review the transcript, you probably could see that. Mother had a period of visitation from July of 2012 through November of 2013, over a year. This was not a single incident request by Children's Services to terminate her visits. The testimony indicated that, in fact, Mother would come to the visits and tell her children, "I've just about finished the case plan, you're coming home soon." When in point of fact, that wasn't accurate. The caseworker would take her aside and he would say, "You can't tell your children that, that's giving them false hopes." And after those types of behaviors were confronted a couple of times, then she went to another level. The testimony was that she was showing her children pictures on her phone of a dead kitten and then of a dead infant. I'm not sure what the reasoning was behind that, but that was the next level. And then she was taking her developmentally disabled son into the restroom and taking pictures of his private parts. So this was an escalating thing. And
Well, let me ask you about that. So these visits were all supervised to be
Yes.
Okay. Why were they allowing her to take the child into the restroom by herself if it was supervised?
I
That's
don't
a bad
know
situation for everybody.
It is. I don't know the answer to that, but I do know that occasionally that does happen. I mean, for whatever reason, it did happen. I think she had her adult daughter with her at the time that they went to the restroom, if I remember the testimony correctly. Maybe not the best decision, but that was what happened. So Children's Services, and again, Children's Services doesn't take away someone's visitation. That's something the court does. The agency sought and was granted an emergency case plan amendment to end the visits or suspend the visits. Mother filed objections to that. A full hearing was held in the trial court on that very issue in front of the magistrate. The magistrate then ruled that mother's visits would be suspended. I think oftentimes it's the hope that that's kind of a wake-up call for a parent to move forward on their case plan, that, hey, you know, your mental health is impacting your ability to see your children. This mother was represented by counsel throughout, and although the visits were suspended in November or actually the hearing was concluded February of 2014, she didn't file a motion to reinstate or do anything to get her visits going again. Now, in listening to counsel's arguments, I actually hear two different issues. Number one, did the fact that she had no visitation from February of 14 to September of 14 when this trial was held, did that impact the trial court's decision to grant the legal custody? And then number two, was it an abuse of discretion for the trial court to not award ongoing visitation after the grant of legal custody? Although visitation is not a directly addressed element in the best interest factors, I think it certainly would probably come in under interaction and interrelationship with significant individuals. So I think it is important. But there was an entire year when there was contact observed, and after that point, mother's mental health continued to decline, culminating in a very serious incident where she was found wandering in a marsh with serious frostbite. The testimony was that despite being discharged after 30 days in the mental health facility, she still had not gone back on her medications, had not followed up with follow-up treatment. So there was no reason to believe that the children would be any better in her care than they had been during the supervised visits before. And although the children expressed a desire to be with their mother, these are older children, and it's really quite sad that the expressed desire was, I need to be there so that I can take care of her. She needs us to come and care for her, and that unfortunately should not have to be the role of children. In terms of going forward, mother is not precluded from visitation. Mother's mental health must be addressed so that her children can have a beneficial or positive relationship with her. The overriding concern in a child welfare case, in both, the court has to be bound by what's best for the children. True, we must balance parents' rights against that, but ultimately, if you want to raise healthy children, you have to be bound by and make hard decisions that are best for those children. In this case, the trial court did choose the least restrictive alternative, that of legal custody to relatives. The oldest child went with his paternal grandparents. The two girls went with a maternal aunt. And sibling contact was continued. I don't doubt that these children will contact their mother when they're adults. And in all probability at that time, they will assume a caretaker role for her. But for the time being, they need time to be children and to grow up. And that's, I think, what the trial court is doing. Thank you for your attention.
Thank you. We still have a little over 2 minutes.
Great, thank you. Very briefly. It was the only thing I really want to bring up is the characterization of the termination visitation as a wake-up call. What that probably in all likelihood did here was deteriorate mental health and serve to break familial bonds. But we know they still have those things, and I think that consideration is at the heart of what I'm arguing the court was not able to do as far as the determination and abuse of discretion. If this were any custody case, as far as legal custody to a relative, they'd be able to make determinations about what that placement looks like, where it is in the mother's visitation, and in this, they were not able to do that based upon everything in here. And so as such, I would argue that it is an abuse of discretion based upon that, and the decision of the trial court should be reversed. Thank you.
Thank you. Court will take the matter under advisement. A written opinion will issue, be sent to both sides, and you can also check on our website.
Thank you.